Welcome back. Dennis Kennelly on the legal line. We welcome your phone calls. Phone number 661-298-5487. With me is my guest producer this week, Nikki London. And Nikki had an interesting incident happen to her in her youth, which obviously was not misspent. She was working at a young age. So tell us what happened.
I was working for a landscaping company this was in a different state. This was in the state of Iowa. I was doing some pretty hard working tree work and had pulled both of the muscles in my shoulder and was in both shoulders and was off work for I don't know, at least a month. I had cortisone shots, I had all this crazy stuff. I obviously wasn't able to do the work. And in the process of trying to get unemployment while I was off work, there was an unemployment phone call that I had to do with the employer on one line and the unemployment agency on the phone, kind of like some sort of interview thing. In the process of that phone call, the company that I worked for had brought up that I had gone to a concert while I was on medical leave, and so therefore this was grounds for me to not be allowed to get unemployment during that time while I was off work for an injury. Clearly, I wasn't paralyzed, okay? So anyhow, whatever, and in the end, I did not get the unemployment. I was very upset. I lost the job. I was never able to go back to work. Nonetheless, even now, I still have issues with my shoulders due to that whole incident to begin with. So here I am 10 years later.
With sore shoulders.
Still with the same problem. And I just walked away. I didn't know what to do. I mean, what am I going to do? I live paycheck to paycheck and, barely getting on. How am I supposed to afford a lawyer for that?
Okay, well, had this happened in California and had Nikki come to see me, here's what we would have done. First of all, it sounds to me as if she injured herself while working. That would make the injury involved a workers' compensation injury. She does not have to pay for her medical for that. The company's workers' compensation insurance carrier does.
That they did pay for.
Okay, so she actually but in California, she would also be entitled to workers' comp disability, which pays more than unemployment. So in California, she would not have been eligible for unemployment, but she would have gotten workers' comp disability, which could normally run somewhere around 2/3 to 3/4 of what your salary is. So this is a benefit that you should be aware of if you ever hurt yourself on the job. I don't do workers' compensation cases. It's a very specialized branch of the law. But what I do tell people, if they are injured on the job, very simply, report it as soon as you can. You have to make a first report of injury, because what happens is that very often the pain may go away, but the effects of the injury linger on, as it happened in Nikki's case. I mean, she, 10 years later, is still feeling the effects of this. And technically, her company and their carrier should still be on the hook to pay for this stuff. So that's important. Now, had it not been a work-related injury, let's say that Nikki had fallen off her bike or something like that and missed work because of that.
That could have been possible.
Yeah, it could have been possible. Exactly. Then we would have had the issue, what does she do when the initial determination from the unemployment people is not in her favor? And the answer is she's got a right to appeal it. You get a hearing in front of an administrative law judge who will make a determination as to whether what you did makes you eligible, what you did, and more importantly, what the company did, makes you eligible for unemployment. Once again, unemployment is very, very pro-employee. In California, it is extremely pro-employee. And all you basically have to do is prove that if you were terminated for anything other than shooting the CEO, you're probably going to get it. It's very difficult not to get it, but very often some companies choose to try and keep their unemployment insurance rate down, and they try and impact people's right to collect it very early in the process, figuring that most of them won't take advantage of the appeal process. And those unemployment judges are very, very smart. They've heard just about every story in the book. And talk about people who should write a book, they should. And I've been in front of them. Very often, I will use, when I have a piece of litigation, I'm representing somebody, I'll get a company representative appearing at the unemployment hearing, and I get free cross-examination, which is wonderful. And it's under oath, and it's on tape, and it's often very, very useful. And very often the last thing in the world the company expects, because they normally send somebody from the HR department who just expects to go in and testify in front of a judge and has no idea that the applicant or the claimant has got a lawyer. Now, if they've got a pending lawsuit, they should be smart enough to recognize that this is a possibility. But I've had a lot of fun doing that. So, okay. So when do you sign your rights away? And this is where it gets really, really, really complicated, because the larger the amount of money that you're being offered to settle a case, to waive your rights, the harder it is to turn down. And I refer to that as now money, as opposed to, gee whiz, if we took this to court, we could get $1 million. Well, you read about an occasional $1 million employment law verdict, but they're not nearly as common as people think. Most cases, 98% of cases settle. And the key thing is you want to, my philosophy is to settle a case as early as possible for as much of its value as possible, while minimizing the amount of money that the employee puts at risk, either in terms of, if it's a contingent case, the employee is responsible for the cost, which is the attorney's fees and that sort of thing, not the attorney's fees, but the court reporter fees, or if it's an hourly case, it's a lot better to settle it for value early. I mean, everybody wants to get these things settled. It's just a question of getting value out of it. And sometimes, you would prefer, with executives most of the time, I don't have to file a lawsuit, which is nice. Because lawsuits are a matter of public record. And and anybody can look it up. Any new employer can look it up. Prospective new employer. And obviously, in your interview, you don't tell them that you're suing 2 previous employers for discrimination, but they're going to find out about it. And people who are, quote, litigious are not favored candidates of the Human Resource Department, believe me. Okay, we have an email?
We do. We actually have a message from a viewer on Facebook. Lori in Newhall wanted to ask you about what we were discussing earlier. She says that she's working for a new company, and when she went to the bank to cash her first check, it bounced. She wants to know what she can do about that.
Well, that is unfortunate.
Sorry to hear your luck, Lori.
Yes. The best answer is find another job whose paycheck's clear. What you should do is go check with the bank to find out why it bounced, just to make sure it wasn't a mistake. And then I would go right back to your employer's payroll department and say, hey, you guys gave me a check and it didn't clear, which means I haven't been paid. And under the state labor code, if you file with the state labor commissioner, which is ultimately what you would do if they didn't make good on this, you're entitled to a waiting period penalty of up to 30 days. So for every day they don't pay you, they owe you a day's pay. Most people don't know that. It's one of the hidden things in California. So what I would do is go to the company and say, hey, make this right immediately. I'll waive my extra day's pay if you make it right. Of course, if you bounced any checks because of it, you're certainly entitled to ask the company to pay the bounced check fees, and certainly entitled to ask them to write a letter saying that due to a banking error that your automatic deposit or whatever it was not credited, so that your credit rating doesn't take damage. But that's one of the benefits of working here in this state. And the people that enforce that kind of law are the Division of Industrial Relations, the Department of Labor Standards Enforcement. And what their job is to enforce the state wage and hour laws. So what's included in wage and hour laws? Well, it's, are you being paid what you contracted to get paid for? In this case, Lori wasn't. She said she put in the work and didn't get paid for it. Was she entitled to overtime? That's also what they enforce. They enforce penalties for missed meal periods, for break times that were missed. There's one in Van Nuys and there's one in Santa Barbara, and that's where you go. They used to have more offices, but and they're free, and they're in the phone book under State of California, Department of Industrial Relations, Division of Labor Standards Enforcement. Most people mistakenly refer to them as the Labor Board. They are not the Labor Board. That's a federal organization that deals with unions. But it is commonly known as the Labor Commissioner. And that's a good phone number to have because they've got a hammer. And if you're an employer, believe me, you don't want to be on the Labor Commissioner's radar because they have terrific enforcement powers. And as Mark Sullivan was telling us last week, they have a long memory. And they like to collect taxes, and they like to collect penalties. And they are very, very pro-employee. And like the unemployment judges, they have heard every story in the book. So it is a good group if you're an employer to stay on the good side of, believe me. So Lori, I hope we answered your question. And Lori, thank you. You've been part of the show. This is our show. I'm here to be a resource for all of us. Just call, email. The email is dennis@hometownstation.com. Lori got to us, and we look forward to hearing from you. But and the advice that I just gave Lori over the phone is the same advice I would have given her had she called me. Because one of the advantage to these agencies that are here to help you enforce your rights is they don't cost anything. Because nothing is worse than being in a position where you've been fired, you just lost your paycheck, and you've got to spend a lot of money in order just to get the money you're owed. It's not fair. But in California, it works out well for everybody. So what do we do with these severance agreements that we get? The vast majority of the time, probably 95% of the time, we wind up signing them. What we will occasionally do is try and get a better severance package for somebody based on a number of reasons, saying that this is not a garden variety termination. This is a case where somebody really does have some legitimate claims that they're waiving. And the company should pay value for that. And it works more often than not. But the money you spend talking to a lawyer when you get one of these severance packages and releases is well spent, because most of us, it's kind of like when you go to the doctor, you don't know, you know some of the symptoms, but you don't know what they mean. Well, in employment law, you know what the symptoms mean, you know what the symptoms are, but you don't know what legal implications they have. I mean, Lori had no idea about the 30-day waiting period. I mean, employer bounces one check. If they don't cover it in a timely fashion, they could wind up 30 days of pay. That's 6 weeks for one bounce check.
Wow.
Yeah, it adds up. And lucky for the employer, there's a cap on it. But I would not like to go into the boss and say, hey, boss, by the way, we made a mistake and bounced the check. And, well, did you fix it? Well, nah, she was gone, and we figured, what the heck. And now all of a sudden you got 30-day wage penalty. That you don't need. Plus, you're on the labor commissioner's radar and expect a visit and an audit of all of your payroll practices.
Now we've got another email, this time from Paul in Santa Clarita. He said that he has received a warning notice on his job that contains false accusations. What should he do about this?
Okay, what he should do about it is, as we were saying earlier, he should go into the person that wrote the warning and try and set the record straight. Try and say to him, excuse me, you said 1, 2, 3, and 4 and happened. I think I used an example earlier of you said I was late 4 times last week, or 3 times, or pick a number, and I wasn't late at all. And I can prove it here in my time cards. And what you want to do is 2 things. First of all, you want to get that warning notice out of your file. That's imperative. And second of all, you want to find out how it occurred. I mean, why is your supervisor writing, where is he getting information that's false about you? Is there somebody that's saying things about you that are untrue? Is there a reason for this? Is it because you're in some protected classification? Is it because you're a woman in a predominantly male field? Obviously, in Paul's case, that's not it. But, is it because you're black? Is it because you're Muslim? It could be anything. But you want to find out what's behind it. And if you can't get it squared away with your supervisor, the person that wrote the email, wrote the warning notice, what you do is take it up the chain. Go to human resources and say, hey, put it in writing. Send the HR director with a copy to your manager saying, I talked to my manager, pointed this out to him, and he still won't pull the warning notice. I want the notice. I want it pulled. And I've got a right to have it pulled because it's inaccurate. At
what point, maybe, I guess, if you couldn't get that resolved with human resources, or if it was some sort of a discriminatory situation, is that something that could be handled within the resources department, or would he need to get a lawyer?
It probably, most companies now, if you read their employee handbook, have got internal complaint procedures as to how they want to deal with claims of discrimination or claims of unfairness. And what I would do is read the employee handbook, and when you read it, look for what you do when you have a grievance or a complaint. And I would follow that. But I would also, at that point, I'd call a lawyer, especially the higher profile the job, the higher salary the job. These are jobs that are worth keeping. And what you want to do is, if you're on somebody's target list, if you're not going to be able to keep the job, what you want to be able to do is get as much money as possible to leave, which is what the companies want anyway. That's why HR when they give you one of these severance packages, bug the heck out of the employee saying, have you signed the release yet? Because once the release is signed, they feel the company's off the hook. So if you feel you're being discriminated against, it is a good idea to get some legal advice as soon as possible and get a game plan in place.
Now, would you do that before or after you've gone to human resources?
I'd go to HR. I would go to HR first to try and resolve it locally.
Sure.
Because 2 points. Number one, most people get fired for a good reason. I mean, firing an employee is a pain in the neck from an employer standpoint. So HR wants to make sure that any potential liabilities are handled. So I would go to HR first, but if that doesn't work, I would call a lawyer. Now, one of the things that we're going to deal with on the other side of the next break is how employees unknowingly get into trouble the first day on the job. And before they even start.
Sounds like a fun topic.
And you're going to ask me why, and I'm going to tell you a couple of stories that'll chill you. Because we've all been here. I've been there, Nikki's been there, and you've probably been there. You just don't know about it. So I look forward to sharing that with you and giving you some helpful hints on how to avoid problems down the road, or at least understanding what you're getting yourself into, because you will find out about it soon enough, unfortunately, if things don't work out. So, time for our next break, so I will see you on the other side, and we look forward to talking about how you dig yourself in a hole without even knowing it. Welcome back to the strains of Hush and Whispers by London Rain. Nikki London, lead singer of that organization.
Thank you.
Which I am proud enough to manage. They're a Cleopatra recording artist and currently in the studio for their putting together the final touches on their second album. So, before the break, I told you that you may find yourself in a world of trouble as far as what you've done before you even start, and I'm going to tell you why. And tell me if this story sounds familiar. You've gotten a job, and you've dealt with either the human resource department or Joe, somebody on the line or something like that. But it's your first day of work, and of course you report to the human resource department, and they give you a whole bunch of paperwork to fill out. And it starts with your W-9 form and your emergency contact information, and they explain the insurance options to you, and they do all of that. And then they start to hand you a bunch of things that they preface with, the lawyers make us have you sign this. Anything the lawyers make you sign, you're not signing for your benefit. You're signing for the benefit of the company. So this is where you read carefully, and if you have any sense, you ask them, "Excuse me, can I have some time to really look at this?" Because one of the things that you'll have you sign, believe it or not, is an arbitration agreement, which says that if you don't like the way things are going on there, and if the company breaks the law, if you feel you've been discriminated against, or if you've been even the victim of improper pay practices, that you've got to take that to arbitration. You can't use the agencies. You can't go to court. You can't get a jury. And many people sign this and have no idea what they've signed. What I tell employees is, you're in a hurry to get started that first day. And I think it's an excellent idea. If you can't take the time to read everything at the time that you start the job, go back. You have a right under state law to look at your personnel file and see what you signed. You might be surprised. You're probably going to be surprised to find out that you've agreed to abide by the company policies, most of which you have no idea what they are. I had one client recently who confessed he didn't read English. And his wife didn't read it much better than he did. And she read the company policies to him. She read the English version and tried to translate those into Spanish. Now, did he have an accurate idea of what policies under which he was working? I sure as heck don't think so. So get a look at what you signed, and if you can take the time at the front end to actually carefully consider and carefully read what you are signing, do it. We're wrapping up here. It's been fun. We appreciate the emails. We appreciate the phone calls and look forward to more of them. I'd give you the number now, but we're out of time. I want to thank my producer of the week, Nikki London, my engineer, Aaron Delatorre. And if you want to get in contact with me, go to the website, DennisKennelly.com, and it'll tell you all about me and the services that my office offers. And we look forward to hearing from you. Next week, I'm talking right now to two agencies, both the Labor Commissioner and the Department of Fair Employment and Housing. Hope to have one of their representatives on. So for now, goodbye. Look forward to speaking with you next week. Dennis Kennelly on the Legal Line.